Hey, good morning, everybody. Welcome back to Law and Legitimacy. Rumors. Hey, good morning, Mike. What's
Morning,
up with
Norm.
you in North Carolina?
It is as beautiful as it's ever been in North Carolina. We've got a week full of sunshine and 80-degree weather.
Oh, that's midsummer in Vermont, but I guess it's spring in North Carolina. So we're back. Rumors of our death are overstated. Last week, I melted down abruptly on Wednesday. Had a lot going on that I needed to think about, was preoccupied, and didn't really feel like following the thread of the conversation we started. So, Mike, thanks for picking up the baton. We took a couple days off. I did an interview with Eric Huntley and his crowd, Laid Back Law, on Friday afternoon. It said something at the end that led people to say we were holding up shop here. We're not. We're back. The world is alive and filled with possibilities and interesting.
Your mic all of a sudden got super low. You just want to yank it out and go wild style. You're muted.
If it ain't me, it's the tech.
Look, I thought about this in the shower this morning. Don't make any other assumptions based on that. But you know, one way you will know that Norm and I are not AI is AI could not do what we do here with our tech mastery. So anyway, good morning. And yeah, you were talking about being on Laid Back Law on Friday, which was excellent. And you were talking with Eric Huntley. And toward the end, I think you made a remark, something about, shutting it down, And over the weekend, I was, kind of probing the audience here, trying to figure out if people actually thought that we were dead in the water, which is just wild. You guys got to have a little more faith in us than that. We are only men, though.
Yeah, I don't know what I said. Maybe it's Alzheimer's, creeping in, but I hope not. Anyhow, so Mike and I were talking a little bit before the show, and this might be a good intergenerational discussion, because I was struck by the stories involving Harvey Weinstein and the reversal of his New York State conviction and the grounds for that reversal. So struck that I took time to read all 78 or 77 pages of the New York Appellate Court decision to try to understand the law. And we're going to talk a little bit about that today, because if you're listening to Law and Legitimacy, you know we're lawyers and we like to talk about the law. But in mentioning it to Mike had an interesting reaction, which was?
Yeah, when I saw the Weinstein stuff begin to circulate, I saw some headlines and understood that some appellate decision or some appellate court reversed
appellate decision.
Yeah, some court decision reversed, a prior decision, and I was met with this recognition of I don't care. I could not care any less if I tried. And then when I heard you discussing that with Eric Huntley and Viva Frey and all of the gentlemen there on Laid Back Law on Friday, that to me.
And by the way, where were you? I thought you were going to join us. I kept waiting for you.
Oh, I was doing, real law work. You know what I mean? And so I was met with that realization that I didn't actually care about the Weinstein stuff, that somewhere in the last several years, I had sort of dispatched any sort of interest in what happened with that further. Weinstein to me was entangled in sort of that Hollywood underground sort of conspiratorial nature of how actors and actresses have to, get initiated into sort of the elite club of A-list celebrities, and that he was some sort of version or some sort of organ within that larger anatomy, that the Me Too movement had its own excesses and own sort of legitimacy problems, but that it could come home to roost with Weinstein. And at the point that he had been convicted of various things in different jurisdictions, I know that he was in court on the West Coast and in New York City. I think somewhere, Norm, I just stopped caring about that. It wasn't something that was interesting to me in a way that I could, that was practical for me. But because you care about it and so many other attorneys that I know and respect and watch care about it, I think maybe that's where I'm sort of humbling myself to say, what about the law in its intersection with Harvey Weinstein in, late April of 2024 should I care about?
Well, I can tell you that, but I want to focus. So let's talk about levels of analysis and the complexities of experience. There is Harvey Weinstein, the sociocultural cipher. That is the person who represents
a collection of things in the public sphere about which people care a lot or not at all. And to the degree that people don't care at all or don't even know who he is, they've got their own set of cultural norms and experiences and ciphers and tokens that energize them and mobilize them. And, this becomes a huge insight potentially into our second topic today, if we even get to it, which is what's going on in campuses with respect to Israel and Gaza. Because, there are people who look at the phenomena of what's going on in the Middle East and have radically different perspectives on what the world is and should be, depending on their affective connection to the events. And so there are those who are adamantly pro-Israel, those who are adamantly pro-Palestine, some people who don't care at all, implausibly, or though it may be to others about this. And the result is a world of conflict. And what's conflicting are ideals and perceptions of self, and the priorities that people place on experience. Some people more energized, as it were, by a support for Israel, some more energized by a support for Palestine. Most, I think, somewhere caught in the middle, saying, isn't there a way out of this conflict that isn't going to cost more bloodshed? And the task of statesmanship, obviously, is to find it. But let's return to Weinstein. As a cultural matter, Ronan Farrow, I think, from the New Yorker, broke the story about Weinstein in a book and in pieces, I think, in the New Yorker. And what we got was an insight into a world of older men using women. So the Me Too movement held for their advancement and dehumanizing women. From the men's perspective, business is business as usual. This was the casting couch. Harvey got what Harvey gave access to power, and what he got was access to bodies. And this is the way it's been done from time immemorial. And you put these two perspectives in one room and get them to talk, and the talk is likely to result in screaming and fracturing of worlds, rather than an understanding of something. Just what that is, I don't know. So I don't know how to comment on Harvey Weinstein, the cultural phenomena. I know that as a lawyer, I've had several conversations with Weinstein. I can't really talk about.
Yeah, that's one of the famous things, right? Is that at one point there was some level of consultation and perhaps the potential for you to be engaged to represent Weinstein in at least some of the allegations against him, and that never came to fruition.
No, it didn't. But I got to know him and his situation, and I got to know, and I have an awareness of the law in this area, and the law is complex. And so let's talk about what I know, at least, about Harvey. I can't decipher Harvey's place in the socio-political landscape. I know that I have outraged many years ago by saying, with respect to a sex case, this may have been involving Saifullah Khan, a Yale student accused of having unconsented sex with his classmate. He was acquitted. And I think I said on courthouse steps somewhere, it's only sex, stupid. Well, we know better. Sex is a powerful attraction and bond between people, and it creates explosive sociocultural and psychological realities that people have to deal with. It changes the world. I think, what does the musician Van Halen say? One touch is all it takes to lose your place in time. And there's something to that, and what people who play at sex play with fire. But Harvey was convicted of engaging in unconsented, non-consensual sexual intercourse with 3 women, and sexual assaults with 3 women, referred to in the New York appellate decision as claimants A, B, and victims A, B, and C, or complainants A, B, and C. And these were women who were engaged in career making in Hollywood. And Harvey, as a great producer, as a fixer, as a mover and shaker in Hollywood, had power.
if you wanted to get ahead in Hollywood, you had to. It helped you a great deal to get to know Harvey, and if Harvey liked you, he could open doors for you that might not otherwise be open. A good friend of mine in New Haven once dated a very beautiful woman in New Haven, and they were affianced. It didn't work out, and she was heading to Hollywood at some point, and he warned her. He said, "You know, you're beautiful here in New Haven, but you're just one among many beautiful women in Hollywood. You're not going to stand out. Don't think that your charms will open necessarily doors." And in Harvey's world, you know, he was at the intersection of so many people with so many desires, so many ambitions, and you get the impression that he was a kid in a candy shop. You know, all these beautiful women wanted something, and Harvey had access to it, so he took what he could get to broker that. And it's ugly. You know, it's an ugly set of accusations. Now, was it a crime with respect to complainant A, B, and C? The law of consent is that if a person does not consent to sexual contact and you engage in it, then it's a crime. And it's a crime if it involves intercourse. It's a more serious crime. If it involves mere touching, it's a less serious crime. If it involves harassment, it's a less serious crime still. And the penal code grades these offenses in terms of their seriousness and their consequences. Harvey got convicted. So in order to make its case, and you know, the dynamics of sex, I mean, those of you who have not been involved in the defense of sexual assault cases only know what you read. You know, you meet a person who's been accused of this, and there's a sort of murky, steamy quality to the relationship between this person and the other. And that the murk and the steam makes it impossible sometimes to tell exactly just what happened. You know, in that moment of passion, when everything erupts, no pun intended, you know, two people find themselves in the position that the Bible talks about. The two people become one flesh. And as they move from that moment, both then construct narratives about what occurred. And so from a defense perspective, on a consent defense to a sexual assault case, the common theme is sex with regrets. You know, a person lowered their boundaries, they lowered their inhibitions, they became one with another, if only for a moment. And at the moment of departure, when circumstances drew them apart, they had to come up with a narrative that explains their position in the world. And so you accuse the accuser of saying, you know, what you wanted becomes unacceptable now that you've had it, and you need an explanation in the world. And your explanation is, I was raped. That's sex with regrets. And so a cross-examiner will push that theme and look for ambiguous tells in the build-up to the relationship to suggest that the woman put herself in a position of wanting this because she did want it. You know, from the state's perspective, the man is a user. You know, he's using his position of power to set, or his position of superiority, because there's often a power relationship in these dynamics, to get what he wants, which is the satisfaction of his sense of domination, of control, of lust, or whatever it is, depending on the relationship. And so he took what he wanted against the will of the woman. What if in many of these cases it's both?
What if life is complicated and complex, right?
And you know, it is. Nowhere more so than in the sex cases.
So this is directly from the opinion, 4-3 opinion from the New York Court of Appeals. I just wanted to read this just so, again, we kind of stay disciplined around what actually happened in terms of the legal foundation. So, quote, defendant was convicted by a jury for various sexual crimes against 3 named complainants, and on appeal claims that he was judged not on the conduct for which he was indicted, but on irrelevant, prejudicial, and untested allegations of prior bad acts. We conclude that the trial court erroneously admitted testimony of uncharged, alleged prior sexual acts against persons other than the complainants of the underlying crimes, because that testimony served no material non-propensity purpose.
And so let's talk about that. In the United States, we say, as a matter of fundamental constitutional law, that a person is presumed innocent unless and until the state produces proof beyond a reasonable doubt. And we say that we try the crime, not the person. Thus, if I'm accused of bank robbery and the elements of bank robbery are entering a federally insured facility with the intention of taking money and taking money, or if that's what the elements are, that's what the state has to prove. It doesn't have to prove I'm a bad guy. And so my not having paid parking tickets, or my having engaged in maybe been accused of a sexual offense earlier in life, that has no bearing. That's propensity evidence. That has no bearing on whether I committed the crime charged, bank robbery. And so typically propensity evidence is prohibited. And it's prohibited because it will lower a jury's view of a person in the eyes of a jury. And it would therefore diminish or undermine the state's burden of proof. And the result is, an unfair trial. There are exceptions to the propensity evidence rule. They are categorized in Section 404B of the Federal Code of Evidence, Connecticut in 4-4. Every state has them. And so exceptions to propensity evidence are when evidence of uncharged misconduct, that is, conduct not charged in the case at bar, is used to prove something like knowledge, intent, plan, preparation, motive, opportunity, identity, absence of mistake. In these instances, the state has to show the court that offering uncharged misconduct will have a bearing on this material fact. So, for example, a famous example cited in the New York opinion here is two men are at a gas station. One apparently goes in with a gun and robs the teller, and then hops in the car and they drive away. Both men are caught. The driver says, "I didn't know he robbed the guy in the gas station. I was just driving. He didn't tell me anything about it." It's a complete defense, because in that case, he doesn't have a guilty mind. So how are you going to prove that he knew? In the New York case, they found a prior conviction for being a getaway driver. And that went to his knowledge, arguably, of what happened at the gas station. And it was admissible evidence, and the man was convicted. And I gather the use of that was upheld on appeal. In the Weinstein case, 3 women who previously had unwanted, they claimed, sexual contact with Weinstein were permitted to testify to shed light on what happened between Weinstein and the 3 women who were at bar in the case against him. And the court held the trial court permitted that in as a means of showing absence of mistake and intent. Somehow, in some very broad way, Harvey's use of his power to get to satisfy his libidinal desires. The appellate court upheld that, the first round of appeals. The highest appeals court in New York said no. This is an improper use of propensity evidence. And I didn't understand the ruling until I read the decision. My first thought was, are they getting rid of the propensity evidence rule? Are they gutting it? Not the propensity evidence rule. Are they getting rid of the rule, that permits you to introduce 4-4 or 404B type material? And they've not done anything of the sort. What they claimed is that on the facts of this case, in other words, the mechanics of the rapes, so to speak, there's no ambiguity about whether Harvey used force to overcome the women. This isn't the case of the guy driving the getaway car, where there's 2 universes, one entirely inculpatory, the other entirely damning. In other words, one innocent, one guilty. I didn't know, I knew. In that case, the use of propensity evidence becomes, or the use of 4-4 evidence, prior uncharged misconduct, prior bad acts evidence. In that case, that evidence helps a juror make a decision. There's nothing here in the mechanics of the act that Harvey performed that will be explained by introduction of prior bad acts. If a woman's pushing him away, and that's her testimony, and Harvey overcomes that force by force of his own, what's the fact that he did this before going to say? That he misunderstood being pushed away? No, the appellate court suggests that intrinsically this event is such that there's just no ambiguity about it. And so I think I agree with the 4-3 ruling with the majority. The minority opinions, and there were two of them, the three judges joined in them, basically took a broader view of the case, and that is that from a socio-cultural and a political perspective, the dynamics of power that men have and use with respect to women are such that this is an important case, showing the dynamics of that power. I'm not sure I buy that. I mean,
you listen to the here taking directly from the first line of Justice Singh's opinion. Fundamental misunderstandings of sexual violence perpetrated by men known to and with significant power over the women they victimize are on full display in the majority's opinion by whitewashing the facts to conform to a he said, she said narrative, by ignoring evidence of defendants' manipulation and premeditation, which clouded issues of intent, and by failing to recognize that the jury was entitled to consider defendants' previous assaults. This court has continued a disturbed trend of overturning juries' guilty verdicts in cases involving sexual violence.
And it talks about the Molyneux rule. That's the name of the case. Everything in the law has the name of some unfortunate person who is charged and whose case becomes famous. I'm not sure that that's the right level of analysis, because that's making the Weinstein. What?
Look at the comment.
Oh, yeah.
The dog backwards. Yeah, good one. That's good.
Yeah. On a serious note, I'm not sure that I'm not sure that the minority view didn't take a more socio-political view of the case than a legal view of the case, it goes back to what Mike and I talked about immediately. High-profile cases. I begin to wonder, having been involved in a few myself, I begin to wonder whether high-profile cases confuse a socio-cultural analysis with the legal analysis.
Sure, and that's sort of what I was hoping we would get here, and I know that the other angry dog and several other people in the stream are wondering how this relates to Trump. And the great thing is the New York Sun actually wrote an article, and that was what we opened here with, this picture and the title 1-800 the Donald. As President Trump's trial gets underway, New York's High Court comes in with a ringing defense of due process for criminal defendants, even those with dubious reputations. And Norm, is that not ultimately what we're getting at with this?
Is that another A.R. Hoffman piece?
No, this is from the staff, but this is right on the target as far as I'm concerned, because we began with my question of general apathy or ambivalence as to the Harvey Weinstein stuff culturally, socially. From a legal perspective, it's interesting. But if we have a situation as we do with Trump, where there is a state court prosecution, there's a district attorney that's widely regarded as having been pushed and persuaded and ran a campaign for election on his promise to get Trump, right? And if that's the case, and this is as high profile as it is, what does this decision mean, if anything, for justice in the Trump case? And I think I'll answer my own question with a bit of sort of black-pilled cynicism. It's
black-pilled cynicism. Explain that to those of us.
So pessimistic, long on pessimism, and very just cynical as to the theory of the article. Because I think it's correct, but in a perfect world, there is the article is written from a place of hope and faith, right? Does this mean that there is some, and the New York Sun is, so I don't confuse anybody that maybe doesn't read the New York Sun. The New York Sun is not very favorable to Trump, right? And they don't hide the ball on that. You'll very rarely even see pictures of Biden. And so I'm just noticing things on that site. But what they're doing here is asking the question of with respect to the Weinstein case and with respect to a court of appeals being able to analyze something as seemingly narrow as the propensity evidence in the Weinstein conviction, what of the court in Trump, and what does this mean for him? So the black-pilled cynicism on my part is, well, justice delayed is still justice denied. And as I've said before, my issue with all of this is that even if there's a bad faith motive that is guiding sort of the state in these prosecutions and these moves, even something as frivolous and stupid as the FTC outlawing non-competes, right? The problem is in the reaction and the chain of events that it sets into motion, right? And so Trump will only ever be vindicated on these grounds in a similar situation where it becomes an appellate issue. And as somebody in his position who is what, 78, 79 years old at this point, and Harvey Weinstein, I don't even know how old Harvey Weinstein is. This picture makes him look decrepit. You think that he's going to be able to sustain a new trial on this, even with the conviction in California standing tall, right? He's still convicted. He's not getting out of jail, but this doesn't do anything for Harvey Weinstein. Maybe it does something for the idea of the rest of us schmucks out here that perhaps.
Well,
right?
it may not, it may not. I mean, Harvey's pragmatic position may not change at all. He remains behind bars in California, and he's entitled to a new trial in New York, which he may not live to see, or if he does, the results may be moot. California, I mean, obviously his California conviction is under appeal. So, usually when you have a person in custody who wins an appeal, the first line of negotiations with the state is, can we negotiate something where we give you a conviction in exchange for time served? That is the fallback position. So if you're not a lawyer and you wonder what happens after an acquittal, not after an acquittal, after a reversal on appeal where the client is incarcerated, you go back to the plea bargaining table and you say to the state, all right, look, we've vacated the conviction. He's now going to be free or not, because of the California conviction. Is there a way to avoid a new trial? It always depends on the client. You can say, we'll give you a conviction, but you recognize the time my client served as the consequence, and he remains at liberty, or he goes free. We had a case involving a social service worker who involved himself in some inappropriate way with wards, young women in a home for troubled girls. And I got his conviction reversed basically on the sort of argument that Weinstein's lawyers used. That is, that prior bad acts evidence was used inappropriately. So the appellate court reversed the conviction with direction that if the case is to be retried, this evidence not be used. And so we stand now in a pretrial posture, the case having been remanded back to the trial court, and we've negotiated with the state. Our client is unwilling to accept the felony conviction. The state is unwilling to resolve the case without a felony conviction, so there'll be a second trial. And at that second trial, the state may or may not have a strong case without the uncharged misconduct evidence. We don't know what's going to happen. So in Harvey's case, pragmatically, it may not matter at all. But suppose he wins the California appeal, then he would be at liberty in both jurisdictions, and somebody would have to decide whether it was worth continuing to pursue him. Now, some of us will say, like you, perhaps, Mike, who cares? I don't give a rat's hindquarters about Harvey Weinstein. There are bigger issues in the world. There will be a political constituency that says it's got to be pursued. And prosecutors will then have to decide. And I think that's a decision that prosecutors have a right to make. And they can consider their constituents who appointed them, who elected them, their own values in deciding whether to prosecute or not. Now, some of the listeners are probably saying, yeah, that's it. This is a political prosecution versus Trump. No doubt. No doubt that follows the decision to prosecute the man. But that's the way it is.
And that's my issue. That's the source of my, as I call it, black-pilled cynicism in this case. Is if we're asked to extrapolate to some reasonable degree as to what's going to happen with Trump, and as Jackson Barrett and I have kind of gone back false narratives through the court, that's the issue. Is that it doesn't nullify that, right? This appellate decision, I think, if someone is as optimistic as they possibly could be, it would be that the prosecutors in the Trump case, in the state Trump case, are somehow going to look at this decision and be, oh, my eyes are open. We're not going to use these witnesses for fear that our conviction could be thrown out on appeal, or we might have to retry Donald Trump. I don't think that is the overwhelming purpose of this office, right? So if we're afraid, or if we're maybe not afraid is the best word, but if we're aware that there is a politically motivated component to the prosecution of Trump, especially on a legal theory that is being used in a totally novel way, why would we expect that this case would have anything other than the practical impact of saying, oops, I guess we can redo it now on the other side of this if they're proven wrong. Like, oh, so honest mistake. Didn't mean to use those witnesses in a totally novel legal theory.
Well, here's the irony. They didn't need those witnesses, in my view, in the Harvey Weinstein case, because they had 3 charged complainants. And so, so usually it's, state of New York versus one man and one woman. The introduction of the second and third women would usually come in the form of prior bad acts. The decision to consolidate the 3 cases basically served the same function as the use of uncharged misconduct, and they are synergistic, meaning they contribute to one another and they help prove one another. So my view is that New York gets a conviction on the second trial of Harvey because it's 3 people basically saying the same thing. Whatever doubts you may have had about the first are more or less erased by the second and eliminated by the third. So I don't know why New York saw it necessary to have the uncharged misconduct. I believe they offered 5 women in that class, and the trial court permitted 3. But who knows whether the case will be tried again. I hope my phone doesn't ring. I can't really talk about Harvey's in my discussion about being involved in cases in California, but it'd be a funny story if he ever waved.
So we have kind of run up on our time, but I wanted to quickly, if you've got maybe 30 seconds, Norm, to offer on the campus protests and hate speech, or if we want to slot that maybe for tomorrow and pick.
Yeah, let's slot that for tomorrow, because that the hate speech thing, we've long predicted on this stream that the United States Supreme Court would soon be forced to grapple with a substantive limit on speech, even political speech, if it lacked any, if it lacked redeeming political value. Now, it strikes me that the sort of speech that's being engaged in on campuses now involving Israel and Palestine is classic political speech, and that it is entitled to the full and robust protection of the First Amendment. But yet, there are reports over the weekend that at least on one campus, a paid provocateur was saying, "Kill the Jews." That may not constitute incitement, that may not constitute a true threat, but is that over a line? It's one thing for marchers, Nazis, to march in Skokie. It's another thing for men to march in Charlottesville saying, quote unquote, "the Jews shall not replace us." It's another thing to affirmatively cross the line and call for the death of another. And it may be that in this stew, we begin to see what a regulation on hate speech consistent with the First Amendment might be argued to look like. What the Supreme Court does with the issue, if it gets framed and it gets up there, kaboom! It's another one of those issues like Roe versus Wade and Dobbs versus women's health. But my sense of watching the political landscape is we've got a whole series of kaboom issues out there. And, Mike, what I'm about to say here will surprise you. But, the third topic, which we didn't even, mention, is, equity-inspired capital gains increases. What is really going on in the discussion about reparations? And are we reaching kaboom moments there in the courts? There's a lot of pent-up pressure in the American political in the American political life right now, and that pent-up pressure is going to find its way into litigation, and that pent-up pressure and that litigation is going to find its way to the Supreme Court, and then the court's going to make decisions that define the landscape of rights and responsibilities for generations to come. And we will be right here with you, charting those decisions as they occur, what they mean, how they get made, and what the law looks like on law and legitimacy. We are back. We took a couple days off. Thank you all for your love and support. As you know, I've had some issues in my domestic life that have required a lot of attention and time. I'm taking the time to do the work, but I'm not forgetting about law and legitimacy, and neither is Mike. So thank you for listening. AMF Yo-Yo, Mike, how do people find us?
AMF Yo-Yo, you can find us on YouTube, on Rumble, and on LawPod Daily, on X as well, at LawPod Daily. You can also find the audio-only streams uploaded right after the stream ends every morning on Apple Podcasts, Spotify, Google Play, Overcast, wherever you find premium podcasts. So, 8 a.m. Eastern time, every Monday through Friday, unless we're taking some time off. So thank you guys for being here again. Norm, glad to be back in the saddle. I feel a little bit fresh. Maybe we should do that from time to time, is just take a few days rather than, running the marathon without any end in sight,
Well, I mean, the goal obviously is to build a viewership and to monetize this thing so that we can spend more time and do better work. And the fear is you take a day off, you lose your momentum. Folks, talk us up, give us some support, spread the word. There are new sheriffs in town. When it comes to defining the legal landscape, you ain't going to do better than you're doing here. So let others know. AMF, Yo-Yo.
AMF, Yo-Yo. See you tomorrow, Norm. See you tomorrow, everybody.